All right, so we're here today to talk about payment bonds and mechanics lien and bond waivers. Hold on, I got to get my share screen going. Okay, we're here to talk about payment bonds. That is chapter 14 of our book, The Construction Law Survival Manual. This is my name, Jim Fullerton. Here's my email where you can email me with any questions that you have. I did write a book called The Construction Law Survival Manual, which you can get a hard copy at the NACM bookstore, but you can also use that book for free on this website whenever you wish to. And I wanted to point out, I'm going to have to switch screens, but let's see, stop share. Let's see. Share. Oh, I guess, let's see, Emily, select a window. Let's see. I'm not having trouble switching screens, sorry. Okay, now you should be looking at the website now. I'm sorry, I was having a little trouble with that. So if you go to fullertonlaw.com, this is the website. Here is a link to get to the Construction Law Survival Manual. You could do that by pushing on a picture of the book, or you can always get it on a banner that's usually across the top. But if you go to the Construction Law Survival Manual, you will see there's a number of chapters, other subjects that we've had seminars on. Contract terms and preserving rights is what we will do in the next seminar. What is it, November 9th? It's sometime early in November. Doing business with disadvantaged business enterprises, the Uniform Commercial Code. But more than half of the book regards mechanics liens and payment bonds and trust fund laws in Virginia, Maryland, and the District of Columbia. That is the most complete book on those subjects in existence. Today, we're going to be talking about primarily chapter 14, performance and payment bonds. We're not going to talk about performance bonds so much as payment bonds here today. We will also discuss mechanics lien and bond waivers. You actually find that at the end of chapter 2, the contract terms and preserving rights chapter. So you could open those chapters now if you wanted to look at them. We are going to pretty much, this isn't always true with all the seminars we do, but in this case, we're really going to work through this chapter 14 pretty much in order from beginning to end. And then we will cover the mechanics lien and bond waivers, which is at the end of this chapter 2, pretty much in order. Let me also point out the appendices on this side. All kinds of the perfect proposal for labor and materials, the perfect supplier proposal, personal guarantee forms, trust agreements. These are joint check agreements, essentially. Change order form. But then you get into the mechanics lien forms, and I wanted to point out 2 exhibits. 31, payment bond claim notice, there's no particular form required for a bond claim notice, but this notice will satisfy the statute. To jump ahead a little bit, all you need to know to send a bond claim notice, the most important thing is who you send it to. Who is the bond principal? Usually the general contractor. That's usually the only required recipient, and your notice must only identify the person to whom you were supplying labor and materials, and must describe the dollar amount you are owed with substantial accuracy. So it's even clear you don't have to be exactly correct on the dollar amount owed. And that's all you need to know to make a bond claim notice. It's pretty simple compared to, say, mechanics liens. And the other form I wanted to show you is the chart of Mid-Atlantic payment bond rights. This is Appendix 33. It will give you a summary of the differences between federal projects, Virginia, Maryland, DC, and Pennsylvania, on the Miller Act bond claims and what they call the Little Miller Act. Most states, perhaps all 50 states, have adopted a public bond statute that's very similar to the federal Miller Act, and those are usually referred to as Little Miller Acts. Virginia has a Little Miller Act, Maryland has a Little Miller Act. District of Columbia does. As a matter of fact, it is identical to the federal Miller Act. There are some differences between the federal and most other states, minor differences that we will discuss at the end of our seminar today. Okay, I got to switch screens back to the PowerPoint. Let's see, where's the share screen? All right, so there's the website, my name and address. Let's think about what happened the last time you bought a house. And we're talking about the difference between contract rights, mechanics lien rights, and payment bond rights is the purpose of this discussion. The last time you bought a house, you signed a couple different sheets of paper. One was a promissory note. That's the sheet of paper that said, if you give me $500,000 today, I'll give you $5,000 a month for the next 30 years. That's the promissory note. That is signed by the contract debtor. This enables the creditor to sue the contract debtor and obtain a judgment. Once the creditor obtains a judgment, the creditor has the aid of the court. Now the court will assist the creditor in collecting this judgment through various mechanisms you've probably heard of: garnishments, attachments, a levy, and a creditor can pursue all those avenues once the creditor has a judgment. That's chapter 17 of the book, FYI, enforcement of judgment. If the debtor does not have any assets, the judgment will be uncollectible, so that the collectability of a judgment is very dependent on the solvency of the debtor generally, and whether you can identify and locate assets of the debtor specifically. So the other sheet of paper you signed when you bought a house described a particular piece of property. This was the mortgage. And it said that if I don't keep my promise to pay, if I don't pay according to the promissory note, the lender can sell this piece of real estate and keep all the proceeds until the creditor has been paid in full. That's what I refer to as security. This is an unsecured promise to pay. This is a security interest. It's signed by the property owner. Okay, so a promissory note is just a type of contract. It's very similar to the contracts you have that say, if I provide this labor and material, you will pay me within 30 days of invoice or whatever the payment terms are. But the contracts that you have are an unsecured promise to pay, very much like the promissory note. However, one advantage that we have in the construction industry is that the legislature has provided us mechanics lien rights, which are essentially the same as this mortgage. It gives us a lien on specific real estate, the real estate where we supplied labor and material. And if the contract debtor does not keep their promises, the claimant can foreclose on the mechanics lien. And the procedure to foreclose upon a mechanics lien is very similar to the procedure to foreclose on a mortgage. A lot of people don't understand that. The difference between a mechanics lien and the mortgage is that you'll rarely end up in an argument about whether or not the lender has a mortgage. The problem will be the equity, the value of the property, the priority of the mortgage compared to other liens on the property, et cetera. But it's unusual for anyone to argue, well, you don't actually have a mortgage. The only way that could happen is a forgery. It wasn't really the owner of the property or some mistake about the identity of the owner, but that's pretty rare. Mechanics lien litigation, if you're in true mechanics lien litigation, that's when you are arguing about whether or not the claimant has a valid mechanics lien, whether they have a valid mortgage. And I like to say that true mechanics lien litigation is a battle between innocents. In other words, we file a lot of mechanics liens. In fact, 90% of the mechanics liens we file are what I call glorified demand letters. We file the mechanics lien, telephone rings, somebody wants to send us money to get rid of our mechanics lien. That's because everybody in the contract tiers has enough money and is solvent that the contract debtor can be forced to pay. You know, the owner or the general contractor is holding money on the contract debtor, and they will send that money to the claimant in order to eliminate the mechanics lien. Okay, that's how security works. In the construction industry, you sometimes see another sheet of paper called a personal guarantee. A lot of, almost all suppliers used to do this. They still often do this, especially if it's small, closely held, family-owned construction contractor is the customer. A material supplier might say, well, I'm not going to supply you material. I'm not going to give you a credit line unless you give me a personal guarantee. What's special about a personal guarantee is it's signed by a second debtor. So that if the contract debtor has no assets and is insolvent, the lender has another avenue, another path, and that is to sue the second debtor. And the procedure's the same. In fact, that's a big part of my point. The personal guarantee is another unsecured promise to pay. It's different from the mortgage. It's different from the mechanics lien, which gives the lender lien rights in a particular piece of property. This is another unsecured promise to pay. It just allows the creditor to sue a second debtor. And if the second debtor has assets, that is probably sufficient to collect. But the lender can have the same problem here. The second debtor doesn't have any money either. If a small, closely held construction contractor company goes out of business, often the president and owner, sole shareholder of that company, will also be insolvent, and the material supplier will still be unable to collect the debt. So what is a payment bond? It's one of these. And it is important to understand it is another unsecured promise to pay. I ask a client, often, do you have any security? And they say, well, I have a personal guarantee, or they might say, well, there's a payment bond. And I understand what they mean, and I almost never argue with them, but I want you to understand that that's not actually security. That's another unsecured promise to pay. The trick about a payment bond is that it is usually on public jobs a large insurance company that is signing the personal guarantee. So you have very little or no risk of that second debtor being insolvent. But one of the most important points about payment bonds is you do need to worry about that. Who is the bonding company? Are they a large solvent insurance company, or is it, there are problems with sham sureties, surety companies that don't really have any assets, and they usually travel with the construction contractors that are very weak financially. The only bonds they can get are from weak bonding companies. So this is something I want you to be aware of and want you to focus on when you're evaluating a project and how much money to lend. You want to think about who's bonding company and look them up on Standard & Poor or the best company. There's a number of free websites that we'll get to later where you can look at the strength of that bonding company. Okay. Now, the concept of sovereign immunity is you can't sue the king. By the same token, you cannot file a mechanics lien on public property. So that right, that possibility is eliminated on a public project. The public takes a dim view of people like me filing a mechanics lien on a post office or on an elementary school. That's interferes with the governing body, and you're not allowed to do that. There was a problem with this. Actually, the original purpose of the mechanics lien statute for us students of history, the original purpose was to promote the construction of the nation's capital in Washington, D.C. And if you want to develop a property and you want to build an economic infrastructure, a mechanics lien statute will promote that activity. So this was a problem on public projects. Since there were no mechanics lien rights, it was difficult to get material suppliers and contractors to lend money. It was difficult to get them to bid on public projects because they were lacking that security. So in response to that, the federal government passed what's now known as the Miller Act, which requires a payment bond on most public construction projects. And it's really better than mechanics lien rights. You generally would rather have mechanics lien rights than mechanics lien rights. You like it even better if you have both of them, which on some private projects, you will have your mechanics lien rights, but there will also be a private payment bond. You have both, that's best. But if you have your choice of having only one or the other, you would generally prefer to have payment bond rights than mechanics lien rights. They're simpler, cheaper to enforce. It's less of a battle between innocents, or less likely to be. The insurance company is in the business of taking that risk and paying claims. So they're not quite as innocent as, say, a bank that had to foreclose on a piece of real estate, for example. There's usually no defense of payment on a payment bond. You'll remember from our mechanics lien lecture that most mechanics lien statutes, including Virginia and the District of Columbia, once the owner pays in full for the project, nobody's going to be able to enforce a mechanics lien against the property. The owner has a defense. The defense is, I have paid all I was obligated to pay. There's no double jeopardy. You cannot make an owner pay twice. Most public payment bonds have no defense of payment. The principal, who's usually the general contractor on the project, the principal on the bond, can be required to pay twice for the same labor and materials. I do represent a number of general contractors, and in my seminars for them or in representing them, I'm usually pounding on them to make sure they police those payments, make sure that their contractors are getting payment to the material suppliers on the project, because you, general contractor, are at risk of having to pay again if payment does not get to the supplier. Enforcing bond rights is cheaper and easier than mechanics lien rights. It's just less complicated. All right, the Federal Miller Act is the mother of all bonding statutes. That's where it started in the 1930s. The contracting officer on new construction projects should require the general contractor to provide a payment bond. Now, there's a couple, that's a power pack statement. There's a couple of key words in here. It is the contracting officer, that's the manager for the project, for the government, on new construction projects, as opposed to renovations, as opposed to maintenance contracts, as opposed to repairs. It has to be a new construction project, and we'll also learn that it has to be a certain size, at least $150,000 project or so. And they should require a general contractor to provide a payment bond. But if it's your problem, if the contracting officer does not do that, if the contracting officer fails to do their job and fails to require the payment bond, that's your problem as a claimant. You have no cause of action against the government for failing to do their job. That brings us back to sovereign immunity. You cannot sue the government. So it behooves you not only to make sure the bonding company is solvent and a reputable bonding company, but you simply need to make sure the bond is there, that there is a bond. There's no substitute for getting a copy of the bond. Okay, there are various types of bonds: bid bond, performance bond, payment bond. We're here today to talk about payment bonds that ensures that suppliers and contractors are paid on public projects. A general contractor is also required to supply a performance bond. That's very important, as between the owner and the general contractor. That is insurance for the owner. If the GC fails to complete the project, the bonding company must come in and complete. But the point for our purposes today, since this is a seminar for claimants, that you have no cause of action under a performance bond. A performance bond does not help you, it only helps the owner. A bid bond also only helps the owner. That's a insurance policy that says if this general contractor bids on the project, but then goes out of business or fails to actually sign a contract, and the owner has to reprocure, and the project becomes more expensive, that the bonding company will pay that additional premium. So those three bonds usually come in a package where the principal pays a single premium and obtains a bid bond, a performance bond, and a payment bond in one package. They don't usually buy those separately. There is another type of bond, a mechanics lien bond. If you remember from the mechanics lien lecture, if you file a mechanics lien on a piece of property, one thing that might happen is that the owner or the general contractor obtains a bond from an insurance company so that the court will agree to remove your mechanics lien from the land records. My main point for today is that that is not a Miller Act bond. That bond is controlled, or the mechanisms are controlled by the state mechanics lien statute, the manner in which a mechanics lien can be bonded off. And we will not be talking about that today, but save that for a mechanics lien lecture. Okay, so a federal project operates under the Miller Act. Any state project or any county project or agencies of any county or state, such as the school board, operate under the Little Miller Act of that state. Those Little Miller Acts are patterned after the federal Miller Act, but sometimes there's usually some differences. Sometimes the differences are more significant, sometimes they're less significant. But if you understand the federal Miller Act, you basically understand how bonds work, but you should be aware that there can be differences, and that's something you may want to look at. Private projects can also be bonded. It's an important question to ask, because that it may not even be public knowledge that the project is bonded. The general contractor generally may not want you to even know that the project's bonded. So it's one of the most important questions never asked. You have to remember to ask the question, is there a payment bond? And you usually want to do that in the bidding stage. As a material supplier, for example, you can ask if the project is bonded and suggest that if the general contractor can give you a copy of the payment bond, you will be able to bid the project more aggressively. And that's a true story, because you have less risk of loss. You have a lower cost of doing business if the project is bonded. And you have a lower cost of business doing work on public projects for that reason. And you have a lower cost of business on a private project with a bond. But the terms of that bond are not controlled by any statute. So one of the reasons you need to get a copy of a private bond is you need to read it. You need to read it if there's ever a problem on the project in any of that. That is what controls, that is what tells you how you need to give notice, the timing required for that notice, et cetera. And so in all cases, you really want to get a copy of the payment bond before you begin shipping labor and materials, but that's especially true of private bonds. Okay, most government jobs provide bond protection, except at small government jobs. It was originally $100,000 minimum. That's somewhere between $150,000 and $200,000 now, because they had some automatic CPI increases. And so I think it's about $170,000, $180,000 minimum. So really small jobs might not be bonded. And you got to be a little bit careful with a large job being broken into a number of smaller jobs in order to avoid the bonding statute. I actually had that experience one time. The contracting officer thought they were doing the world a favor. They thought they were helping the public by breaking a $300,000 job into $300,000 jobs. So there was no bond, and the taxpayer did not have to pay for bond premiums, but it left all the claimants unsecured, which creates a different problem. The biggest place I have seen this problem, lack of bond on a bigger project, is a maintenance contract. I can remember back in the 1980s, a case that we had that involved the installation of new rooftop HVAC units, heat pumps for the Pentagon. That was a multi-million-dollar contract, taking all those heat pumps off of the roof of the Pentagon and putting new heat pumps up there. But that job was not bonded. And, and I was working for the supplier, manufacturer of HVAC equipment. And fortunately, we realized that and could explain to the client, no, this is not a construction contract. This is a maintenance contract. This is not bonded. So they had to check the creditworthiness of their customer much more carefully and had to think about requiring alternate security. You can also have problems with quasi-governmental jobs. That can be Fannie Mae. There isn't necessarily a bonding requirement. If the government is a tenant, I remember I had a general contractor client who was building an office building in Tyson's Corner. And it said Sally Mae outside on the new home for Sally Mae, I think it was. And so you might assume that's a government contract. You might assume that's a bonded project, but it was not, because the government was a tenant. The government had signed a 50 or 70-year lease on the building, and a private owner was building it and was going to lease it to the government. The Miller Act simply didn't apply. There was no requirement that it be bonded. Recently, the partnerships, PPPs, and I had, my internet connection's unstable. If I lose it, I'll try to get back on as fast as I can. When HOV lanes were built in the Beltway, going around Washington, D.C., and this was early on. I think it may have been the very first HOV lane project, but the lanes were built right in the center. You had the northbound lanes and you had the west and southbound lanes, and you had empty space between those lanes. And that's where they put the HOV lanes that are still there today. And I had a client who was a stone supplier. And, that was obviously a government project. It was being built on government property. And so, of course, it was bonded. And they, did their credit management accordingly. And they ended up where they were owed over $300,000 on the project and did not get paid, and contacted our office. We went to try to get a copy of the payment bond. There was none. That was a private project. It was being built on government real estate. So you had no mechanics lien rights. We could not lien the HOV lanes, but there was no payment bond. The government was not building the lanes. A private partnership, Floor Lane Company, was building the lanes, and they did not require payment bonds. Now that probably wouldn't happen today, at least not in a Department of Transportation, Virginia Department of Transportation project like that, because they the state statutes now require bonds on triple P projects like that, but it's something to think about. It's another instance that you need to see a copy of the bond. You need to confirm that the project is bonded and the identity of the bonding company. So again, the bottom line is get a copy of the bond early. In all these cases, that's really, there's no substitute for doing that to evaluate the strength of the bonding company and confirm that the project is bonded. The other reason you want a copy of the actual bond early is the form that it's written on, and a bond is a contract signed by the general contractor and signed by the bonding company that gives you rights against the bonding company and the general contractor. And the way that bond is written might give you more rights than what is required by the statute. And the only way you'll know that is by seeing a copy of the bond. Okay, so there are a number of free places you can check the rating of the bonding company. These are all on page 346 of the book, or page 14-38. It's the same page. You've probably heard of Moody's, Standard & Poor, Best Company. They all have websites. You can just go plug in the name of the bonding company and it'll either say A minus, B plus, B minus, or C. And anything up to, B plus is probably okay, or maybe even B. Anything lower than that, B minus, or certainly a C, you need to be a little bit nervous, maybe look into it a little bit more, think about your other, the strength of your customer, et cetera. You could also check the financial management services, the U.S. Department of the Treasury, to see whether or not that bonding company has been approved for federal projects. It's just another free place you can evaluate the bonding company. There are real problems with sham sureties and private sureties. I had a project early on, this was back in the 80s, well, it was actually a renovation project of apartment housing, essentially, for enlisted families on Fort Belvoir. And it was actually right across the street from where the hospital used to be, where I was born, Lewis Heights in Fort Belvoir. And a bond was required, but the contracting officer allowed a private surety. That's just a really rich person who signs the personal guarantee. And just like a personal guarantee from the president of a construction company, you need to worry about what's the strength, the solvency, the net worth of that guarantor, of that surety. And in this case, they had falsified their financial statements, claiming to own a whole lot of real estate they did not own. And of course, it was a weak contractor who had to use that type of private surety, and they defaulted and became insolvent. And there were 11 or 12 payment bond claimants, all in the federal court in Alexandria, Virginia, suing these private sureties who were entirely insolvent, and nobody got paid. So, and that was a federal job, and that can happen today. It's unusual, but it can happen. Sham sureties and private sureties. Okay, how to get a copy of the bond. As a practical matter, this is one of your biggest problems, real problems. My best suggestion is to get it at the bid stage and talk about your ability to provide better pricing on your labor and materials. If you are a material supplier, you can team up with your customer Material supplier credit managers are often, more experienced at this than their customer who works for the subcontractor. And you can coach your customer, the subcontractor, that the sub wants to verify the bonding company as much as the supplier does. And look, customer, subcontractor customer, let's go get a copy of the payment bond from the general contractor. We can confirm the project is bonded together. We can, I can get you better pricing on the materials. You can bid the labor and materials contract more aggressively, and we'll get this project together. We'll lower our cost of business without lowering our profit. Okay, after a problem occurs, the best way to get a copy of the bond is to contact the owner and threaten filing a mechanics lien or threaten lawsuit under the project on the contract. And government owners are normally required to provide a copy of the bond to any claimant. I put it that way because it's still often difficult, it's sometimes difficult to get a contracting officer to provide a copy of the payment bond. If nothing else, they're bureaucrats and they, are busy and they're hard to get a hold of. But I actually had a contracting officer in the District of Columbia one time tell me that they didn't want me disrupting their project and interfering with their contractor on the construction project, so that they would not provide me a copy of the payment bond. And that, I filed a Freedom of Information Act request, but the deadline for filing the lawsuit against the bonding company expired while I was trying to get a copy of the bond. And that's happened to me once in 35 years, but it is, again, something to think about. And it's a reason you'd much rather have a copy of the payment bond before you supply rather than later. So if it's a public owner, as long as you have enough time, you got to do it early. Contact the owner. They're supposed to give you a copy of the bond. If it's a private project, you can threaten filing a mechanics lien, and that will typically motivate an owner to give you a copy of the payment bond. All right. All right. Who's protected by a Miller Act payment bond? So from here forward, we're talking about the Miller Act, unless I say otherwise. And again, the rules are usually the same in the different states, and less certainly the same on a private project, but they often are the same. And I'll try to point that out as we go along. Who's protected by a payment bond? A second tier sub, this blue bar is the breakoff point. Everybody below this blue bar is not protected by the payment bond. The federal government requires the payment bond. They're the owner, also referred to as the obligee, which those are confusing words, but they're words you will hear sometimes in connection with bonding. They are the obligee, the recipient of the obligation. They have a contract with the prime contractor, who also the general contractor, referred to as the principal on the bond, and also referred to as the obligor. They're the ones that are obligating themselves under the bond. The surety is also obligating themselves under the bond, and they have contractual obligations to the government and to the principal on the bond. So anybody who has a contract directly with the prime contractor has rights under the payment bond. That's always true. And as a matter of fact, we'll learn in a few minutes that it's not necessary for them to give the GC notice within 90 days of their last supply. The GC knows that they haven't paid these first tier subs and suppliers, and there's no need to give them notice. A second tier subcontractor also has rights under the bond, but they are required to give notice within 90 days of their last work. And that notice, that's referred to as a bond claim. We were looking at a bond claim form in the appendices of the book a little while ago. That notice is sent certified mail, typically by the second tier sub to the general contractor. We'll talk about the claim notice in detail later, but they are required to provide notice, and a supplier to a subcontractor is required to provide notice within 90 days of their last work. A first tier sub does not need to give notice. Their first requirement is to file suit on the bond within 1 year of their last work. Again, we'll get into more detail on enforcement later. No notice requirement. Everybody has the same requirement of filing suit within 1 year of their last work. A second tier sub or supplier has an additional requirement of providing written notice 90 days after their last work. Okay, so one of the main points of this chart is that a supplier to a supplier does not have bond rights on a federal project, even though this supplier is at the same tier, their second tier supplier. The way the Miller Act reads, the way it's worded, it says that the bond shall ensure payment to any claimant who has a contract with the prime contractor or a subcontractor of the prime. And the federal case law has been that a supplier is not a subcontractor. It's a definitional thing. The courts have just decided that a subcontractor is defined as somebody who's on site performing a particular portion of the work. So this gets a little dicey. So many parts, these are definitions are from the 1930s and 1940s. Nowadays, so much of a building is pre-constructed offsite and delivered finished whether you're a supplier or a subcontractor is often debatable, but it's an issue that you need to be aware of. What about material not actually used on the project? This is a big difference between mechanics lien rights and payment bond rights, and it's one of the reasons that a material supplier would prefer to have payment bond rights. You don't have mechanics lien rights unless and until your materials are actually attached to the real estate. When you deliver a pile of lumber out in the parking lot of a construction project, and the project just stops right there for whatever reason, you do not have mechanics lien rights because your materials have not become a part of the real estate. Under mechanics lien theory, that's what does it. Your blood, your energy, your material adds to the value of the real estate. You add improvements to the real estate, and your mechanics lien rights come from those improvements that you constructed and contributed labor and materials to. The Miller Act statute is worded differently. It says the Miller Act bond will be to ensure payment to all persons supplying labor or material for the performance of the contract. It does not say, though, that material has to actually be incorporated into the project. It just says that it has to be supplied for the performance of the contract. So under the same facts we were just talking about, you deliver a pile of lumber and it's sitting out in the parking lot of a Miller Act bonded project, you will have bond rights for that delivered material. However, it is necessary, again, this is just the case law, the statute doesn't say this, but the case law has been pretty consistent that you do have to actually deliver the materials in order to have bond rights, because you have not supplied those materials for the performance of the contract until you have delivered them. So again, the off-site precast concrete manufacturer or some other manufacturer or supplier, you may be building things custom for a particular project, and you may be performing just as much work as an on-site contractor, but you can still have a problem collecting, getting paid if you have not delivered that product to the project. Okay, labor or material furnished for performance of the general contract, you have bond rights. If you have this brings us to the good faith, reasonable belief rule. If you have a good faith, reasonable belief that you are supplying materials for performance of the general contract, or you still have bond rights, even if the contract debtor moved those materials to another site. And I've seen this happen many times. A material supplier will cut off a subcontractor that has a bad payment history or is weak financially. The material supplier might refuse to give them any more credit. And then oftentimes, if this was a live seminar, I'd be asking a credit manager in the audience, well, what if that subcontractor showed up at your office or emailed you a copy of a payment bond and said, look, this is a federal job I'm doing now this time. And here's a copy of the payment bond. Will you extend me credit on this project? And a lot of suppliers would do that because they have less risk of default on a bonded project, and there's a strong bonding company guaranteeing payment. Well, I've seen it happen several times that a debtor will have material delivered to a bonded project and then will move that material to a different project where they really wanted to use the material. What's that? Or you have a similar problem with counter sales. The subcontractor comes in and says, well, this material is for this bonded project. And so the supplier gives them credit, but they take the materials away somewhere else. Anyway, my general contractor clients need to understand that they're still at risk of having to pay for those materials, even when they are diverted to another project. If that supplier had a good faith, reasonable belief that they were supplying material for a bonded project, they still have rights under that bond, no matter where the materials are eventually used. And that's very different from mechanics lien rights. Okay, interest and attorney's fees. This is another reason you might really like bonded projects and like them better than mechanics lien claims. The federal Miller Act bond is security for the amount unpaid to the claimant. And the courts since the 1930s have said that these words, it used to be sums justly due. The statute was amended to say amount unpaid, but that seems to have made no change in the way the courts interpret this. It focuses on what is contractually due to the claimant. The amount unpaid will include 18% interest if that's what the contract says. And the amount unpaid will include attorney's fees if that amount is contractually due. There could be other forms of penalties and consequential damages. It all depends on how the contract is worded. But the bond claimant is going to be able to collect the amount unpaid under the contract. Notice you must have a contract saying 18% interest and saying attorney's fees in order to be able to get that. So this is another instance that it's important to have good contract documents. If you've got a good contract or a credit agreement that calls for interest and attorney's fees, you can make the bonding company pay. If you do not, to jump ahead to the next seminar about contract rights, if the debtor has not agreed in a written contract to pay your legal fees, there's no way to make the debtor pay your legal fees. It doesn't matter how egregious their default is. And similarly, if you don't have a contract calling for attorney's fees, that is not an amount unpaid that you can recover under a payment bond. Okay, so think about what this means. These are the contract tiers, or what I call the contract tiers. The US government's at the top, they're the owner. They have a contract with the general contractor. The general contractor has contracts with multiple subcontractors, and those multiple subcontractors have contracts with multiple suppliers. There might be a contract down here between the sub and the supplier. This supplier required a credit application that called for interest and attorney's fees. Sorry, jumping ahead, I think I'm missing part of this slide. The bond is up here between the US government and the general contractor. So this general contractor may not even know this supplier's on the project. The general contractor probably has no idea that the sub has signed a credit agreement calling for 18% interest and attorney's fees. But if this sub does not pay this supplier can require the GC, even if the GC has paid the sub in full, this supplier can make this GC pay again for the materials and pay all of the supplier's attorney's fees and make the GC pay 18% interest if those are all included in the amount due to the GC. That's very frightening if you're a general contractor, and I spend a fair amount of time coaching my general contractor clients that they need to police these projects more carefully. But on the reverse side, as a claimant, this is a big part of the reason why you're just not going to have as much payment problem on a bonded project, because the GC is going to be policing payments. They're going to be a lot more careful to make sure all suppliers on the project are being paid. Okay, let's talk about the bond claim notice if it is required. You will remember from the earlier chart that both subs and third tier suppliers are required to file suit within 1 year of their last work. If you do not have a contract directly with the bond principal, there's an additional requirement that you send notice to the bond principal, written notice, within 90 days of your last work. So the notice is not necessary if your contract is with the bond principal. A subcontractor who does not have a contract with the bond principal must state with substantial accuracy the amount claimed and the name of the party to whom the labor and materials were furnished. That's a pretty easy test to pass. You just have to know who you have a contract with and how much you're owed. The real trick is that you have to know who the bond principal is. You have to know who to send the notice to. And and I've had cases that my client, the supplier, if it's an inexperienced supplier, doesn't even know who the GC is. That makes it impossible to send the GC notice. And so you're essentially waiving payment bond rights for no good reason by not having any idea who the GC is. It is not clear in the statute, but I would advise you strongly to make it clear in your notice that you are making a bond claim and that you are looking to the GC for payment. In other words, there is case law where a supplier had been sending copies of their invoices to the GC, saying, well, here's invoices for the material we supplied to your project, GC, and we're not getting paid. And that did not constitute notice under the Miller Act bond because it didn't make it clear that we are expecting you to pay, general contractor. We are looking to you for payment, or I think it's better to just say, this is a claim on the payment bond on this project. That's the best way to make it clear. We'll go, I think the next slide is a copy of that form we were looking at earlier, the bond claim form, but notice when we get there that it's going to multiple recipients. I think it is a good idea to add copies of invoices and delivery tickets. The more information you provide in the bond claim notice, the better. Communication is the objective. Nobody's ever going to pay you until you make it clear or show that you did in fact supply labor and material to this particular project. So you might as well just give them that evidence with the initial notice. It will probably speed up payment. At least show you are competent and communicative. But you also want to send it to multiple recipients. Here is the bond claim notice, the same one we were looking at before. It's Appendix 31 in the book. You'll notice it's going to the GC, the owner, and the surety. Why are we doing that? The Miller Act requires only that notice go to the principal on the bond. That's the general contractor. However, I urge you to send notice to anybody who ever walked past the project and anybody you're aware of, the architect, the engineer, the surety, certainly if you know who that is, the owner, if you know who that is. The whole objective is to try to freeze money. And as I think I explained earlier, if the parties, upstream parties are holding enough money, the owner's holding enough money on the GC or the GC's holding enough money on the subcontractor, they're going to freeze that money and they're going to make sure it gets to the claimant to avoid problems. And the claimant will never have to hire me. Listen to me carefully because I'm talking myself out of a job here. I'm trying to avoid work. If you can contact the owner, the surety, the general contractor, the architect, the engineer early when you're getting payment problems, Bond claim notices are pretty simple. You don't really need a lawyer. If you're owed 100 grand plus on a project, you probably want to call us to make sure your bond claim's in order. But especially if you're owed, 20, 30 grand, a letter could do it. The issue is who it goes to, stating who you have a contract with and describing the project. It's an easy test to pass. But the more people you can send this notice to, the greater the chance you're going to be able to freeze money. And even on a private project, I think it's a good idea to send this out. In other words, one of my secret tricks is you don't even need to know that a job is bonded in order to send a bond claim notice. If you know who the owner is, and you'll remember from the mechanics lien lectures and the security lectures, I'm telling you, you want to collect that information on every project you're on. What's the owner's name and address? What's the GC's name and address? What's the architect's name and address? And most bonds, you only have to give notice to the GC, but if you send a notice to the owner and the GC when you're starting to have payment problems on a project, and you say, we're working on our mechanics lien rights. In the meanwhile, this is a claim on the payment bond, send a copy of the payment bond this way. If you can do that, if there's a payment bond, you have successfully preserved your rights under the payment bond by providing notice to the bond principal, number one. Number two, it tends to freeze money so that it makes it more likely you're going to get paid, and more likely there will be no defense of payment under a mechanics lien action if you end up filing a mechanics lien later. Okay, so for that reason, you're going to send multiple notices by multiple methods to multiple addresses to multiple recipients. You cannot send too many notices. The only possibility is sending insufficient notices. In other words, multiple recipients, we just finished talking about, the owner, the GC, the surety, if you know who that is. If you have more than one address for the general contractor, send it to both addresses. Multiple methods. The Federal Miller Act today says that you can use any overnight service that a third party signature is required. That means FedEx or USPS is okay. The Federal Miller Act used to say it had to go certified mail. And so you had to make sure you send your notice 85 days after your last work, so that you could make sure it was received by certified mail within 90 days of your last work. Now it's a little better because you can use Federal Express. You can send it overnight, but I would suggest to you that in addition to sending it Federal Express, I would always send it certified mail because that's cheap. That just costs a couple dollars. If you have a fax number, you send it by fax. If you have an email address, you send it by email. Because all court case law that I have read has a rule saying that even if you didn't receive notice by certified mail or whatever the exact requirement is, but you did actually receive a copy of the bond claim during the deadline period, that's sufficient. And I think even an email, if you have an email receipt, that would probably be actual notice of your bond claim and would be sufficient. So, I mean, especially if you're owed a lot of money, you're going to send multiple notices, multiple methods, multiple addresses to multiple recipients. Don't take a chance. all of your time and money is going to be in preparing the notice and figuring out where to send it. Once you've done that, send it to every address that you have. Okay, delivery of the notice. Any means, this is federal Miller Act statute, any means that provides written third-party verification of delivery. That's FedEx, that's USPS, that certified mail also works. But the case law is that well, this varies a little bit from state to state, but some states rule that the notice must actually be received within 90 days. And that is the federal rule, must actually be received within 90 days of your last work. Most state Little Miller Acts say certified return receipt requested. That's what the Virginia Miller Act says. That's what the Maryland Little Miller Act says. But they also have actual notice rules, so that, again, I would still send it Federal Express, but make sure you send it certified mail, return receipt requested. But I would also send it Federal Express. I would also email it. I would also fax it, however way that you can. It is clear that written notice is required. There is plenty of case law that calling the GC and telling them you haven't been paid and telling them you're going to sue on the bond does not do it. It does need to be written. I think that in most instances, that written notice must make it clear that the claimant is looking to the bond principal to pay. If you're too late, if the horse is already out of the barn, informal notices sent may work. Look at your email. It is possible that an email you sent is sufficient written notice of your bond claim. Maybe, have a look. But for planning purposes, your job is to send multiple notices, multiple methods in a good bond claim form. Okay. My rule, you'll remember from the mechanics lien lecture, you got to move within 90 days from your last work. And that is the deadline for a federal Miller Act. We'll learn later you have a little more time in some instances, the Maryland Little Miller Act, for example. So the federal case law is that the bond principal, the GC, must receive that bond claim within 90 days of last work for which such claim is made. This is getting a little lawyerish, but since we don't have a limit to time on these remote lectures, we go get into things in a little more detail. For which such claim is made, the significance of those words is that paid deliveries do not extend time to make a bond claim. And where this comes up is a supplier may refuse to provide any more credit on a project because the sub is not paying them in a timely manner. But then the subcontractor says, well, how about COD deliveries or paid deliveries, or I'll pay you in advance for a delivery. But I need more stone. I got to have more stone or I'm going to be in default. And the supplier might do that. And that makes perfect sense. That's the way to preserve a relationship with a customer. You can help a customer, might just have cash flow problems because of a few nasty owners or GCs that are slow in payment to them. You can help them out, preserve a relationship, and you're not risking any more money by increasing the unsecured debt that you have. So it may make sense to do that, but I want you to realize that those COD deliveries do not extend your time to make a bond claim. Once an invoice is 90 days old, or once 90 days have passed from your delivery, you need to go ahead and send a bond claim. You might even tell the GC and the customer, look, we're going to continue supplying the project COD, and we're going to help make sure this project gets done. But but we need to make it clear. We need to preserve our Miller Act rights under the statute and send this notice today. And if we're not paid in another 9 months, we're going to be filing suit to enforce our bond rights. Okay, so trivial work, repair work, warranty work may not extend bond rights. I say may. Maybe I should say will not extend bond rights, because that is the clear rule under the Federal Miller Act. There's plenty of Federal Miller Act case law that repair work and warranty work does not extend bond rights. Trivial work's a little bit harder, because if it's new work it's just something you haven't done before, but it's clearly in your contract. Even if it's pretty small, it probably extends your bond rights. But repair work and warranty work, if it's work that was there once, but it got damaged somehow, or you did install it, but you made a mistake in the way you installed it, and you have to fix it under warranties, it will not extend your Miller Act bond rights. And I would be fearful that a Virginia state court or a Maryland state court would make the same decision, because since the Miller Act and the Little Miller Act are so similar, the state courts tend to follow the federal case law unless you can show them there is a difference in how the statute is worded. They usually will follow the federal case law. So, okay. So how do you enforce your bond claims? We've been talking about the notice. That's something you mail within 90 days of your last work. Everybody has to enforce their bond claim with a lawsuit. And if we're talking Federal Miller Act, that's within 1 year of your last work. If you have a contract directly with the bond principal, that is your first deadline, is 1 year after your last work. There is a 90-day nuisance rule. You're not allowed to file suit under the bond until 90 supply on the project. And so as a practical matter, where this becomes a problem, if you as a supplier or a sub, if you have a contract to supply a set amount of material for a set project, and you're in a dispute about whether there's defects in the labor or materials you're supplying, and your customer starts withholding payment for that reason, you may call me and say that you want to stop work or stop deliveries because you're not getting paid. And I'm going to ask you, well, do you have a contract to supply a set quantity of labor and materials? And if you say yes, I'm probably going to say, no, you need to be really careful about stopping work. That's a very risky proposition. And we'll talk about that more in the next seminar. That's a contract issue, but it's almost never a good idea to stop work on a project. We might file a mechanics lien. We may make our bond claim. We can file suit, but continue working because it's usually too risky otherwise. But so you can end up in a situation that I'm telling you, you really should keep delivering to the project. And in the same breath, I'm going to tell you, no, we cannot file suit on the bond because you have to wait until 90 days after your last delivery on the project to file suit. So yes, you're going to keep delivering to the project. No, we're not going to file suit on the bond. But what I will also tell you is you can sue under the contract. Go ahead and sue your contract debtor. But that's sometimes the only thing you can do. Okay, So your deadline to enforce your bond claim with a lawsuit is 1 year after your last labor and materials are supplied to the project. Again, that's Fullerton's rule, the lowest common denominator. You will, in Maryland particularly, you'll have usually much longer than that to enforce, because in Maryland, you have to file suit within 1 year after the government accepts the project, and that's usually a long time after the last labor and materials are supplied. The wording on the statute's also different here. You'll remember that I said that you had to send your notice within 90 days of the last supply for which such claim is made. And in other words, paid deliveries did not extend your time to send the bond claim notice. The wording is different